Representative Randleman is recognized to explain the committee substitute.
Thank you again, Mr. Chair. House Bill 805 comes as a request from the Association of Clerks of Superior Court, and it will change the requirements for a name change. For those of you that work in the court system, you already know what the process is for a name change, but for those who are not, I will explain. A name change is categorized as a special proceedings, and they fall under the jurisdiction of the Clerk of Superior Court in the county where the applicant resides. Currently, other than identifying information, the application must include proof of good character, being an affidavit made by at least 2 citizens of the county who know the applicant's standing. House Bill 805 amends the statute to now include identifying information. It will also include the certified results of an official state and national criminal record history check and a sworn statement that the applicant is a bona fide resident of and domiciled in the county where the change of name is sought, whether or not the applicant has been adjudicated a bankrupt or is subject to a current judgment, and if so, where and when, and whether or not the applicant has outstanding tax or child support obligations. The clerk is required to instruct the applicant on the record check process, and of course, in any case, the clerk can grant or deny the application. The bill adds a new provision in subsection G, allowing the clerk on his or her own motion to set aside an order granting the name change for fraud or misrepresentation after notice to the applicant and an opportunity to be heard. This law does become effective when it is passed, and it will apply to applications on and after that date. And again, I request your support.
Committee, we need to look at this bill carefully because after this session's over, we may all be so unpopular that we need to change our name.
I'm the Nash County Clerk of Superior Court, and I'm very interested in this addition to this bill because of an egregious set of circumstances that happened in my county where a rapist can change name by misrepresentation, assume the name of his victim, and then released from prison and moved into her neighborhood. And I have worked on this for approximately 2 years, and I promised this young lady I would do everything possible to get a procedure in place where I can hold a hearing based on the evidence, and it found to be to reverse this name change.
I understand the bill based on the context you just expressed. I do have a question about item 3B on page 1, line 19, about the bankruptcy status or previous bankruptcy filing, apparently ever a bankruptcy filing, whether they're currently in bankruptcy or have at some point in time in their lifetime have been in bankruptcy or filed for it. What is the justification or need for that? I still don't see the need with the other information that's being provided why the question of their bankruptcy or previous bankrupt status would be necessary in this procedure.
Well, if they have filed a bankruptcy, and it is under the current name that they are using, then those people in the future would like to know that they have in fact filed a bankruptcy. So this document will actually show that they have filed a bankruptcy. And if they have any outstanding judgments, and that way they're going to know that it was in that prior name.
Thank you, and I do understand the need if this were a credit context, since we below take into account any outstanding tax information and any child support information. Those would be debts that would be owed to the state. But in this situation where there might have been a bankruptcy at least, and again you asked for 2 categories. Have you ever filed a bankruptcy, even if you've gone through it and completed it? And then, do you have one that's existing or an existing order? It seems again that that bankruptcy component, either the past one that's been satisfied or both the past and the current would not be necessary. Again, that becomes a credit matter, And if you do a bankruptcy or you do a name change and you go to have credit established, then clearly you're going to have a new credit record. And so whoever goes there is going to see you don't have any credit. And that can't get much bigger tip off than to say you have no credit and you're 40 years old. Then obviously, you know, you're in a witness protection program or there's something going on that you don't have any credit. So I have a concern about that, the need for the bankruptcy provision in there. Agree with the outstanding tax or child support obligations or maybe any other obligation that would be in there to the state.
Representative Daughtry.
You know, the clerk has a discretion. They are quasi-judicial officials. And this is in their discretion that they can ask questions even today, isn't that right? And so I don't see why they shouldn't be allowed. They can already today ask whether or not you file bankruptcy and whether or not that bankruptcy you've been discharged, and how many times you file bankruptcy. They can already do that today. So I don't see what this does particularly other than just spells out that they have that right.
This isn't really to the motion. I had my hand up before the motion was made. I just wanted to ask a question about name changes when women get married. Like if they had a bankruptcy before, so I'm going to tell them they can't change their name. How does that work and how does this compare? And maybe that's too broad a question, but it seems like, you know, it might be easier for women who had a checkered past to get a new name than some other folks. And so that's just my question. I would then advise men who have had financial difficulties to get married and try to change their name to their wives.
So Representative Ross, you're not available.
I'm not looking for that kind of guy.